Good afternoon, I'm DK Rosner, and this is TTT Live. At this time, we're bringing you a live broadcast on TTT, Joke City 91.1 FM, and at TTT Live Online of a press conference hosted by Attorney General Faris Al-Rawi to discuss legislative matters. We take you now to the Office of the Attorney General in Port of Spain.
Everyone, good afternoon. Members of the media, to the listening public, viewing public of Trinidad and Tobago, good afternoon and season's best from the Office of the Attorney General and Ministry of Legal Affairs. Thank you very much for joining us in today's press conference, and permit me to introduce the feature topic, which will be in response to news covered by the Express today on the public procurement positions. There is a need for us to clarify what the law is and what the law is not. And as Attorney General and Minister of Legal Affairs, I'm obliged to take notice of public commentary and in particular to provide clarification on the law as is necessary. Trinidad and Tobago has been engaged in an exercise of printing and relaying commentary, and I say this most respectfully, without the benefit of fact-checking or indeed in a studied analysis of what is and what is not factual and truthful. Today's Express newspaper carried on the front page an article saying UNC threat, opposition calls on government to withdraw procurement bill or no support for any legislation. And in the article by Mr. Ricky Ramdas, I noted that there was a significant amount of statement made by the opposition spokesman on this issue, Senator Wade Mark. Senator Wade Mark said that effectively this is a tragedy to the people of Trinidad and Tobago, and he said this, and it was printed, and I note that there was no attempt to, how should I say, fact check Senator Mark. Senator Mark said this: what is particularly disturbing, he stated, was the elimination of any oversight by any independent body as it concerns the sale and disposal of public assets and public property. Can you imagine, Senator Mark says, the disposal of our assets at the Trinidad Petroleum Holdings Company Limited? Take, for example, Paria Fuel Trading Company. Take, for example, the Guaracara refinery, which is now on the chopping block, as we know, through bid by patriotic enterprises. What the government did in these amendments was remove completely from public view, from oversight by an independent body, of any transactions involving the sale and disposal of our assets. Now, that is just one article that appears in the Express newspaper. There is another article which appears. This is not a product of the paper itself, but instead a guest columnist. It is Public Procurement Collapse Part 2 by one Afra Raymond. And Afra Raymond wrote yesterday in relation to his Part 1 article, and today goes on to say that this law is one which effectively is something that should not be supported. And the writer goes in the course of yesterday's article and today's article to make a very bold assertion that Prime Minister Rowley was wrong in relation to the public procurement statements, and that the government was wrong in relation to its advocacy to change the law. Because the writer said, as far as I've understood his article, that public-private partnership arrangements are not going to be the subject of the public procurement law. And that therefore constitutes 2 days of writing by at least one newspaper. Of course, Senator Mark's comments were covered in other newspapers, but I wanted to, in the envelope, treat with both of these issues now. I'd like to state, first of all, that the public procurement law is the subject of implementation by this government. I'd like to urge those who write about this issue to simply be factual. In Senator Mark's case, I'd go a little bit further and I'd say, please be truthful, because Senator Mark is not being truthful. And in being factual, I would like the nation to be assured that whilst the government is aggressively implementing for its part all that is required in relation to public procurement legislation being put into effect, the government can only do its part. I'd like to remind you that the Office of the Procurement Regulator, which has the mainstay and focus for this structure, that office came around in January 2018, and that office went about producing work that it is obliged to produce, and that it has taken over 2 years of that office being at work for us to get to a plan where they now have some 31 documents in draft form. I noted Mr. Afra Raymond saying that this law is now fully ready for implementation and giving the impression that the government is somehow holding back on the law. I would like to state that there are many steps still required at the Office of Procurement Regulator and outside of the government of the Republic of Trinidad and Tobago to make this law work. And it is very important for us to understand that the government can only do its part. We have established procurement entities inside of government ministries. We have ensured the management of personnel to come into the population of these bodies. We have installed the tracking and mechanisms on our part in public bodies, but it is not only a matter of the outstanding regulations that will bring this law to life. And therefore, it is wrong for Mr. Afra Raymond to say that the law is fully ready for implementation. And it is wrong, and I say this very respectfully, for anybody, including the Office of the Procurement Regulator, to suggest that the matter is almost immediately ready for operationalization. I urge you to go to the public procurement law itself. And very importantly, even though the Office of Procurement Regulator provided me as Attorney General with its draft regulations, which have to be produced under Section 63 of the Act, and which have to be taken to Parliament for affirmative resolution, even though that has been provided to me in October of 2020, that is a couple months ago, at the end of October in 2020, I would like to say that there was a caveat that there would be further submissions coming from the Office of the Procurement Regulator in relation to certain amendments to those regulations. We will sit on those regulations and we will bring them forward to the Parliament with immediacy. But ladies and gentlemen, it is dishonest of writers to suggest that it's only up to that regulation. It is not up to that regulation. I want to refer you specifically to Section 63 of the Public Procurement Act. And Section 63 of the Public Procurement Act is critically important. Section 63, where the general regulations are produced, says this: the minister may, on the recommendation of the office, that is the Office of Procurement Regulator, make regulations to give effect to the provisions of this act, including regulations with respect to, and this is the important one, the conduct of challenge proceedings under Part 5, and the addition to or removal from ineligibility list under Section 58. So far, not a single writer, and I want to specifically include the editors of the Express newspaper that have written, I think, the most in relation to this law. Not a single writer has pointed out the truth that the regulations for challenge proceedings under Part 5 are critically important for operationalization. What are challenge proceedings? Right now, we are focused as a country upon public procurement, the creation of a list, the database, the methodology, the handbooks. That's all well and good. The devil is in the details. When a public procurement is engaged, anybody who is not the winner of a public procurement has the lawful right under the provisions of challenge proceedings issued under the Act from sections 49 in Part 5 onward. Anybody who has not won on a procurement has the right to challenge the proceedings. Those challenge proceedings are set out in sections 49, and very importantly, after you go through asking the public procurement regulator to investigate the proceedings, after the public procurement regulator has seen whether there's something to be answered or not, after that, there is a review process. And I want to point you to the fact that a review board is required. That review board has been appointed. Mr. Justice Ventor, Sebastian Ventor, is the chairman of that board. 2 other members have been appointed, including Mr. Winston Sweet from the University of the West Indies. But that review board, which looks at the decisions of the public procurement regulator on challenge proceedings, that review board is effectively something which requires an office, staff, it requires processes, it requires a system of filing of documents, a hearing schedule. All of these things have to be put in place. In other words, then, that review process, much like the public procurement regulator's review process, requires a form of a court. And until those regulations are produced and the processes have been mapped in the review proceedings, there can be no effective operationalization of the procurement laws, because you can't just have the start of procurement, you have to deal with the challenge to procurement. And the challenge to procurement is a critically important element that must be entertained. Now, I take also careful note of a publication coming from the Office of the Procurement Regulator. And in that public procurement regulator's document, we noticed that the OPR sent out its stakeholder engagement operationalization chart. And the Office of Procurement Regulator indicated that it was engaging with the judiciary and its ICT team, and that e-hearings are a part of their process. The e-hearings are intended, all things going equal, to be looked at by 31st March 2021. But they require a full e-hearing functionality. They still have to implement the case management and whistleblowing solutions. They still have to implement the IFMIS project and free balance software. In other words, then, the software that exists between the government accounting system and the public procurement accounting system. Those 2 pieces of software have to have a handshake, as you call it in technology, and they have to be working together. They still have the full arrangements to be ironed out on the procurement depository and the Microsoft suite. The case management software, etc., also requires, in the database management, for the public procurement regulator to meet with international standards. And I want to speak specifically about data protection. The European Union, as you're aware, has produced the general principles guiding data protection. That data protection principle requires anybody who is from a European origin on the database to have their personal information managed in accordance with the European Union regulations, etc. So I want to disabuse this concept that Trinidad and Tobago can, with a simple passage of regulations produced, achieve the full functionality of the public procurement law. The public procurement law, as it's set out, I invite you all to have a look at the legislation. I would like you to look at what the legislation requires, in particular, the challenge proceedings. The challenge proceedings require the functionality, not only of the challenge proceedings by the regulator, but also the review panel to sit and to have it in operation. That review panel, I'll remind you, is, as it's constructed, appointed by an independent mechanism. The president did so on the advice of, after consultation with the prime minister and the leader of the opposition. That review panel has an entire process that has to be applied to have this thing put into careful construct. The regulations that have been produced so far under draft regulations under Section 63 coming from the regulator are those that involve participation in procurement. They also involve the procurement depository, the pre-qualification and pre-selection in Part 2, the technical requirements in Part 3, procurement methods in Part 4. After we go through procurement methods, which indeed deal with limited bidding, requests for quotations, etc., we then go to procedural safeguards in Part 5. We then get to Part 6 of the draft regulations, and I just want to make sure that I let you know each part. That deals with evaluation. Part 7 deals with the selection of consultants. That Part 7 is where, prior to the amendments that we made recently, you would have to have selection of consultants undergoing basic price and quality positions, effectively requiring you to have regard to the lowest price on the block. Part 9 deals with retention of public property and disposal of personal property. Part 10 deals with the challenge proceedings, and that is therefore something that has to be ironed out in light of the review panel aspects, and that's what I was referring you to in terms of its position. After we deal with Part 10 on the challenge proceedings, we then deal with the ineligibility proceedings, which is also something that I referred you to in Section 63. And after we deal with that, we deal with the miscellaneous provisions. It is Parts 10 and 11 that require the consultation aspect for the challenge proceedings and for the ineligibility proceedings. And therefore, these regulations, which are in draft form, are the subject of a potential split where you can define these things in a better form or fashion. And this is the material that I referred to when I said that we needed further submissions coming from the Office of Procurement Regulator. We last met at a virtual meeting with the Office of Procurement Regulator, and in that meeting, we have to get those final positions worked out. But I would like to stress, none of this can happen until the offices of the challenge proceeding have been fully set up, and those offices have to be driven by the review panel itself, having a location, e-procurement arrangements, e-filing, court aspects put in. So I want to caution against this oversimplification that says you just simply have to pass the regulations. We are not there yet. As we deal with the intention of the government to drive this process, I can tell you now that at the Office of the Attorney General, we have in place a team that is carefully tracking all of the obligations that the government requires to be put into effect so that we can work effectively and efficiently together with the Ministry of Finance, which has technical lead on this matter, as well as with the Office of the Procurement Regulator, and indeed the review panel. We need to be very careful to obey the separation of powers principle. We will not involve ourselves to frustrate or to be involved in areas where we don't have the right to be involved. Our job is to facilitate the development of these areas. And I'd just like to remind you that in the 2 years that we have been in active work on this matter, we have had to await, and we did receive, work that the Office of the Public Procurement Regulator has put into effect, but it took over 2 years of that work to be done. I want to disabuse this understanding or the statements that are repeatedly made, in particular by the opposition, that this law was capable of coming into effect in June of 2015. That is not the case. September 2015 was not the case until you had the appointment of the regulator by the president, which happened in January 2018, the review panel, the establishment of the court mechanisms, the production of the guidelines, the production of the handbooks, which are not yet fully completed. Until those things have been put into place, there could not have been a start to this, but that the government has been actively promoting the development of all of these aspects. As it relates to challenge proceedings and ineligibility proceedings, we require further information from the Office of the Public Procurement Regulator so that those things can be mapped out. Now let's get on to the gentleman who I've described as being untruthful, and that is Senator Wade Mark and Senator Mark's ridiculous submissions that the government has somehow removed the ability for the oversight by the regulator for disposal of public assets. Ladies and gentlemen, members of the media, I urge you to simply look at the public procurement law. And in the public procurement law, I would like you to focus upon the fact that the definition of public procurement, as set out in Section 4 of the law, the definition of public procurement includes public procurement that involves assets. Public property is dealt with there. It means real or personal property owned by a public body. A public body is described specifically as including a body corporate or unincorporated entity. In Senator Mark's examples, you would certainly have Paria, Guaracara, Petrotrin Holdings. All of these things are specifically caught by the definitions in the Act. Secondly, I'd like you to go to the website of the Office of Public Procurement Regulator, and you will see that the website has handbooks in draft form where the issue of disposal of public assets, including those spoken about by Senator Mark, are covered by the Office of Procurement Regulator. It is therefore ridiculous and irresponsible of the elected opposition of this country to send forward spokesmen in the persons of Senator Mark and Mr. Rodney Charles, who participated in that press conference. I want to note that it is not lost upon me that not a single lawyer occupying the UNC benches would dare step forward and say these things, you know. They've left it largely to a non-lawyer who comes up with hysterical arguments that defy the written laws of Trinidad and Tobago and defy the published content on the website of the Office of Procurement Regulator. I wish to condemn in the most serious way possible Senator Mark's statements. I would urge reporting to also include fact-checking. I would urge that our editorials also include a reflection on what the law actually says. And you will note that this government included specifically, beyond what is in the existing law as of 2015, this government specifically included a new Part 6. And that Part 6 includes a new section for the disposal of state lands. Part 6A of the Act, the new Section 57A, we went a step further and we obliged the minister to publish regulations in respect of disposal of state lands, real property owned by the government, real property owned by state-controlled enterprises, and real property owned by statutory bodies. So not only does the law, as it was originally drafted in 2015, include public procurement to involve all of the things that Senator Mark says it does not, but we went a step further and we put in place the disposal of state lands. So I'd like to say that Senator Mark is quite simply ridiculous. Senator Mark has made a threat, obviously on behalf of Senior Counsel Kamla Prasad-Bisesa, to say that they will be supporting no legislation. I would say, what's new? Senator Mark's track record will demonstrate that he says no to everything and has not supported the laws brought forward by the government. including laws, for instance, where we have taken the very laws produced by the opposition when in government and brought them back to the parliament. The opposition, in saying no to the gaming law, for instance, in saying no to a work product of over 4 years in a joint select committee on the very bill which they passed themselves in the House of Representatives, have demonstrated that they are not in the parliament to support anything. And therefore, the government accepts that we will have no support from the UNC, full stop, on anything. They are not interested in Trinidad and Tobago. Had they been interested in Trinidad and Tobago, they would have supported the gaming legislation. It would have allowed us to not be in the horrible position that we are, where we are the only country regulated and supervised. When you look at the IMF publications as the countries that they have looked at that don't have laws to deal with gaming, Trinidad and Tobago is the only country in that pool. And if the UNC was serious about stopping money laundering and criminality and to improve the lives of people that work in that very large sector, they would have supported that law. So to Senator Mark, I say, same old, nothing other than threats. And I would like to say that the submissions coming from Senator Mark are fundamentally dishonest. I'd like to turn to the submission coming from Mr. Afra Raymond. Mr. Afra Raymond put out in very clear form a submission that the public procurement law is going to somehow stop the independent office of the public procurement regulator from having oversight over public-private partnerships. I want to just simply rely upon the written law. When you look to Section 7 and you look to the public procurement law as it has been set out, the first thing that we note is that any public procurement of any goods, works, or services, retention or disposal of public property, this is Section 6, that is not the subject of the Act is void and illegal. That's Section 6. Section 7(1), this Act applies to public bodies and public-private partnership arrangements. Let me repeat that. This Act applies to public bodies and public-private partnership arrangements. The amendments which we made to Section 7 recently, which have been the subject of a significant amount of consideration in the public domain, and now the threats by Senator Mark, the exceptions set out in 7(2) are very clear. To the extent that this Act conflicts with the obligation of the state. Who is the state? Trinidad and Tobago. Under or arising out of the following: A, a treaty or other form of agreement to which Trinidad and Tobago is a party. Stick a pin. For a treaty to become binding on Trinidad and Tobago, you know this in the context of migration well, it must become local law. You know from the experience in FATCA with the intergovernmental agreement with the United States of America, we could not put FATCA into effect, that agreement, that treaty, until we brought the FATCA legislation. So it is ridiculous to say that the treaty doesn't have supervision. The treaty has supervision because it must be made law to be binding on the state. And you cannot, most respectfully, forget the entire publications that the entire media corps dealt with when we were looking at FATCA or Global Forum or the Financial Action Task Force. We cannot forget that, and I urge your editors, please, to remember that a treaty has to be supervised by passage of law in the Parliament of Trinidad and Tobago. The second one, an agreement entered into by the government of Trinidad and Tobago with an international financing institution. We are not talking about a Piarco Airport contract, which was a company, which will be, if it was done today, the supervision of the Office of Procurement Regulator. We're talking about an international financing institution. And let me remind you, for us to borrow money from the IDB, we have to have law. For us to borrow money from the Andean Bank, We have to have law. We have the CAF loans. We have the IDB loans. All of these things are done by law. And therefore, it is, again, ridiculously reckless for people to say that there's no supervision in that regard. The third aspect is an agreement for technical or other cooperation between the government of Trinidad and Tobago and the government of a foreign state, government-to-government arrangements. I would like to state that it's only where they have a procurement legislation or structure in place that that treaty or other obligations rank in priority, they prevail. If there is no procurement structure by these entities, the public procurement law governs. Very importantly, all of those accepted entities in subsection 3, a procuring entity engaged in procurement proceedings relating to a treaty or agreement referred to in subsection 2A shall comply with section 29 and submit a report on such compliance. Section 29 is very detailed in its structure. Section 29 sets out all of the things that the public procurement regulator has to have under the rubric due diligence. So let me put this very simply. When we hear the commentators state that there's been a removal of the Office of Public Procurement Regulator, and that is a blanket removal, that is wrong, it is untrue, and it defies what is written into the law. Secondly, when we hear people say that the treaty is something to cause concern, a treaty must be made law for it to be operative, it must pass through the Parliament. When they say that it's an agreement with an international financing institution, international financing institutions are not the subject of any form of odium or scorn in the international world. Thirdly, when we're looking at an agreement for technical cooperation, foreign state, these things are subjected to the scrutiny of a report from the public procurement regulator under section 29 for due diligence, and that report goes to the Parliament. And as you know, reports which go to the Parliament go to the standing committees of the Parliament for interrogation. So this is entirely untrue for anybody to say that the law has been gutted. What has been gutted is the fact that people don't read, and they are not reading the black and white text of the law. Everything that I have just said to you there is in the law. And when we come now to the exceptions I want to put into fact have been improved by the contribution coming from Senator Paul Richards. Senator Paul Richards asked for the Parliament to consider, and it did, and it approved, the fact that if there are any exceptions for services, medical services, auditing services, etc., forensic accounting services, that those guidelines have to be brought to the Parliament. And therefore, the law says that if you're accepting something out, that the guidelines must be brought to the Parliament. I want to give you an example of what we're talking about. If this law was not amended, we would end up in the ridiculous and dangerous situation where a forensic audit may be ongoing for criminal proceedings. And I want you to think about criminal proceedings, not threatened proceedings. Let's look at actual forensic auditing for matters that have been around for decades. Could you imagine taking a forensic accountant who is investigating a matter for the DPP or the police, and then going out to procure that under the draft regulations produced? You have to send out that notification to all other accountants and auditors. And then those accountants and auditors who don't win roll up and say, hold on, I want to challenge the proceedings. And when you get to the challenge proceedings, you get to section 49, you get to the review proceedings. It is critically important to note that Look at this section, 50, subsection 5. Effective access to all documents in its possession relating to the procurement proceedings have to be given. You have 128 days of saying, no, I want to review, because that's how long the review period can take. After the 128 days, and you finish at the review tribunal, you go to the High Court to challenge the proceedings. After you go to the High Court, you go to the Court of Appeal. After you go to the Court of Appeal, you go to the Privy Council. Let me give you an example. You remember the Piarco Airport inquiry? The airport was built towards the end of the 1990s. We are in 2020 going to 2021. We're 21 years later. Proceedings finished in other jurisdictions. But because of our due process, and I make no complaint with people exercising their rights at law, we have yet to get out of the magistrate's court because we've had challenge proceedings lawfully taken in the magistrate's court, judicial review, Court of Appeal, High Court, Court of Appeal, Privy Council, and come back 21 years later. So imagine the case of the DPP investigating something using a forensic accountant. And that forensic accountant has another person say, well, anybody who has an interest in those proceedings, anybody has the right of audience to challenge. Now, that is a real example of why the exception was made. But I want to again state, we are not doing this outside of what other countries and other places do. Trinidad and Tobago is being fed a diet of, most respectfully, again I would say this, of nonsensical arguments, saying that we have gutted the law. I want to ask you, Jamaica, which has the same exemptions in their Public Procurement Act number 1 of 2015. Guyana, the United Nations Commission on International Trade, UNCITRAL. Kenya, the CARICOM Public Procurement Model Law. Uganda, the World Trade Organization, the United States of America, the European Union, Australia, New Zealand, Singapore, the organization of the OECD, when you're looking at the European context, the European Court of Justice pronouncements, the Belgium judgments. Are we saying in Trinidad and Tobago that all of these countries are sensible enough to have the same exemptions and exceptions that we have, but we in Trinidad and Tobago, because Senator Wade Mark says so, are doing something wrong? Could you imagine someone like Senator Mark, in his examples, abusing challenge proceedings? Not Senator Mark himself. I'm sure he's a good senator, wouldn't do that. But I'm saying, can you imagine what Trinidad and Tobago will go through in the abuse of challenge proceedings? And that is why all of those countries that I've just given you reference to, and organizations I've given you reference to, that is why they have the same exceptions to the law that we have brought about. So the devil is in the details. It is the challenge proceedings that are critical for the operationalization. Let me remind you, we are, for the first time in Trinidad and Tobago's legal arrangements, going to allow for the challenge of public procurement. Usually the courts have stepped away from allowing challenges of a particular type. We are now entrenching into the law a system where $53 billion of revenue is spent by a government in a budget. If you take aside recurrent expenditure for salaries and gratuities and pensions, etc., and you look to the billions of dollars that are left for expenditure, you're now asking one office, called the Public Procurement Office, one regulator, and one review tribunal to take all of those challenge proceedings. You understand what we're headed into? We're headed into something which will be larger than the courts of Trinidad and Tobago. Do you understand that? I want us to appreciate the magnitude of what we're treating with. And therefore, that's when I come back to this submission of saying that the regulations that we have under Section 63, even though Part 10 and Part 11 treat with ineligibility as the Part 11 and Part 10 as the challenge proceedings, those challenge proceedings regulations have to be married up with the process. Ladies and gentlemen, go to the annual report of the Honorable Chief Justice this year. 97% of traffic matters are now gone. 97%. 46% drop in reduction. But it took this government to implement the changes to the law. Demerit points, red light camera, a new system of the courts operating, virtual operations, the introduction of mask technology to do transcript evidence, not computer-aided typing like you see, which takes us millions of dollars. Those are the aspects that have to be built out. You can't be asking a regulator's division that has autonomy and independence. In other words, then the government doesn't set this up for the regulator. The regulator has to set this up for the regulator. And if you don't have the challenge proceedings and ineligibility proceedings right, you're going to crash the entire system. And therefore, I want to respectfully state that in the 2 years, January 12, 2018 is when the OPR was appointed. We are now headed up to January 2021. In the now completion of 2 years going on to 3 years, that is a very short space of time to make sure that all of public procurement can work. And whilst the government is anxious and will give committed and dedicated support to bringing public procurement to life, it is not a simple exercise. And I want to urge people to stop oversimplifying. Stop oversimplifying. Understand that we're working at full bore. We must respect the independence of the Office of Public Procurement Regulator. We will get further submissions from the Office of Public Procurement Regulator, and I invite right now publicly submissions from the Office of Procurement Regulator and the review panel as to the setup and full operationalization of their departments. It's all well and good to say you have some guidelines and they're not all completed, and some handbooks and they're not all completed. All have to be completed. Secondly, you have to have electronic filing. You have to have virtual hearings. You have to have the data protection principles in order. Otherwise, the law cannot work. I give my commitment on behalf of the government of the Republic of Trinidad and Tobago, led by Dr. Al-Rawi, to doing all that is in our power to do this. It is ridiculous of Mrs. Prasad Bisesa, as a senior counsel, forget the fact it's self-appointment, it is ridiculous of a leader of an opposition to witness Senator Wade Mark's tirade and threat, because the laws of Trinidad and Tobago have to be brought to the books if they are deserving of that, not because of some idle threat. I'd like to state that whilst we have had a discussion on public procurement, I want to sound a word of caution to people who speak for Trinidad and Tobago. I heard a most incredible submission coming from Transparency International telling the government of Trinidad and Tobago, bring campaign finance law. Were you asleep? That law is in the parliament right now. I drafted the law myself. The Honorable Prime Minister introduced it into Parliament. And it is before a Joint Select Committee. And why I have just been somewhat disrespectful. Let me say why. Because when people say things, other entities that rank us, global entities, pay attention to what they say. And it is irresponsible of anybody to say bring something as if it is not there already. You owe the people of Trinidad and Tobago a duty of care to be responsible in your statements. And you cannot make statements when you are wrong in fact. I can tell you that I intend to ask the Honorable Prime Minister and the Cabinet to see the reintroduction of whistleblowing legislation. I note that it is the same Senator Wade Mark in the Joint Select Committee that brambled till the cows came home in opposing that law. I expect nothing else from him in that regard, but we will bring that law again, subject to the Cabinet's consideration and approval. So in summary, there is a duty of care for us to be honest in the facts. January 2018, one gentleman was appointed and the board came into effect. 2 years of operation to produce some of the guidelines and some of the handbooks, not all. Whilst we have draft regulations, which also include ineligibility criterion and the review panel, those things cannot work in isolation of the technology. You will have heard me said over and over again, laws work when you look at plant and machinery, people, processes, and the law. And I gave you the example of the U-turn system and how we've had a radical improvement because, ladies and gentlemen, you will recall we've hired over 1,000 people at the judiciary, headed on to 2,000 employment opportunities. So you cannot make this thing work unless you have the details in gear. I respectfully urge learned commentators and learned editors to just pick up the public procurement law. Just pick it up. Have a look at what it actually says, not what somebody tell you they think it say. That is not good enough. Look at what the law actually says. Take a step back and ask yourselves, how will it be operationalized? Do I have the people? Do they have an office? Do they have the systems? Who must originate that process? I'm calling upon the review panel and the Office of Public Procurement Regulator quite publicly today to get on with the operationalization of that by submitting their proposals. Let me ask you, ladies and gentlemen, where is the Office of the Review Tribunal? Who's the registrar? Who's the staff? We're ready to proclaim, ready, but how are you going to do a review? You understand what I'm saying? It's the basic common sense questions. The Minister of Finance can't pick it up upon himself to operationalize this by himself. It must come in a coordinated approach. Now, I want to say this very sincerely and very respectfully. We have some excellent people in the position. I make no criticism of the public procurement regulator at all, and certainly not of the very distinguished people that comprise the review panel. Mr. Justice Ventor is a scholar and a very distinguished citizen of Trinidad and Tobago. These are not criticisms at their feet. I'm talking about the operationalization of these structures. It must come with the recommendations. I respectfully believe that the Office of Public Procurement Regulator, that office is working at full bore. And I compliment the Office of the Public Procurement Regulator, but 2 years for them to operationalize this. When President Carmona appointed them in January 2018, that's when the exercise began. Before that, 2015, 2016, 2017, the government had no role and no function because the government had to wait for the President of the Republic to make those appointments. And that's black and white in the law. So respectfully, stop quoting fiction. Get on with the facts. And I'm saying this because the rest of the world is paying attention. And if newspaper columnists and editors don't reside in the facts, Trinidad and Tobago looks bad. Stop bad talking your country. Settle upon the facts. put pressure in the period 2018, 2019, and now 2020. No problems. That would be lawful and legitimate. Don't pour scorn on the Office of the Public Procurement Regulator, and certainly not the review tribunal. Let's make sure that the rest of it is operationalized. So I end by saying Senator Mark is to be rejected out of hand. In relation to the examples given by Senator Mark, I would simply say, stop being dishonest. Stop it, Senator Mark. That dishonesty is not appropriate, most respectfully, for the leader of the Senate bench, for the opposition. It is not appropriate. It is to be condemned. If the opposition is not desirous of supporting the laws of Trinidad and Tobago, it wouldn't be the first time. No to FATCA, no to Global Forum, no to income tax amendments, no to anti-gang, no to bail law. You could change the lettering of the UNC to NO, no, and it'd probably be in the same basket. So, ladies and gentlemen, this matter having occupied the public attention as frequently as it has, and in particular 2 days running in a row, it is incumbent upon me to tell you what the law says and what it doesn't say. I want to say to the Office of Procurement Regulator and to the Review Tribunal, you have our full support. And we're very grateful for the hard work that that office has been engaged in, but let us make sure that we get the facts straight. May I open myself for your questions? Yes, please.
Newsday, you said, well, basically, before anything can actually happen, these requirements have to take place, right? Now, the question I would like to ask is, exactly what is the time frame for these requirements to be met, and is that up to the government, or does the OPR have to actually do something about that?
The most important next step for the government is in respect of getting to the Parliament as quickly as we can on the regulations. The regulations, as I've told you, are a all-encompassing regulation, including challenge proceedings and ineligibility criterion. In respect of those two matters in particular, the Office of the Public Procurement Regulator will have to give certain submissions to us, but we intend to get to Parliament very early in the new year, subject to the Cabinet's approval of the finalized regulations, to get that on, even if those regulations are perfected tomorrow. Operationalization depends upon a place to do the job, people hired to do the job, and all of the standard form contracts, deposit information, and the data protection have to happen. We have to look very carefully at how we manage data protection principles between the European Union, other countries, etc. So this is not a simple process, and certainly $50-something billion in expenditure. Take away recurrent expenditure, we're looking at billions of dollars of constant challenge proceedings. The capacity of the Office of Public Procurement Regulator is critically important. If we have, legislatively now, we have 64 judges, 15 Court of Appeal judges, 43 magistrates, hundreds of courtrooms, electronic filings, thousands of matters. How many public procurement regulators we have? One. We have one public procurement regulator and 3 very distinguished citizens sitting on the review panel. You understand what we're getting into? Capacity. Remember, if you challenge proceedings, you're up to a standstill period in some cases and 128 days of review, and then you're going to the High Court. That could take you years after that. Are we ready? Conceptually, for what we're about to do is the critical point. That's where the discussion has to be. The government, of course, commits itself to that. So even if the regs are produced immediately, the operationalization, the software, the electronic filings, all of the things that the regulator has pronounced on himself. I'm not making this up. It's the regulator put this out in the public domain that they need to have the e-software for the e-filing, the e-hearings, etc. That is what is required. It's the same way we did it in the courts. So I want this conversation to go right. I don't want it to go wrong. It's not a us and them. The government is prepared to do all of these things. If we pass the law now for the regulations, it has to be operationalized by the public procurement regulator having sorted out his software, structures, and filings.
The actual law, is it on the ministry's website? Because
Which actual law?
the procurement, the full law with the amendments, the most recent amendments included, is that available for public scrutiny?
Well, I can tell you that if you go to the procurement regulator's website, all of that is on the website, save for the last piece of amendments, which are now to go to Her Excellency the President. I have to confirm whether it's been assented to. It's not been proclaimed for sure. And that last bit we will be adding in now. The regulator will update his website. So the laws are fully available between the Parliament website for the last bit of amendments and the Office of Public Procurement Regulator. Up to 10 seconds before I came down here, I double-checked. It is on that website. They just need to add the last piece on. But the sections I referred you to, they've been around since 2015 and 2016.
Thanks, Ryan Hamilton Davis, Newsday again. We have an opposition that basically says on paper that they would support good law. All right. Now, thinking on that, I would like to find out from you what kind of thought went into the amendments made here, and the ramifications of that, seeing as procurement is more or less a middle point for acquiring materials for development, government issues, private and public partnerships, and so on. So what was the thought, and what is the risk involved in bad law in this case?
Okay. Thank you very much for a deep question, an excellent question. I want to remind you, we haven't put our hat on one law. Hasn't been hung on one peg. Let me remind you of the following. Civil asset forfeiture, explain your wealth legislation, removal of beneficial ownership, mandatory issuance of shares, demonetization of cash, amendments to the Proceeds of Crime Act, amendments to the Financial Obligation Regulations, amendments to the Central Bank Act, Securities Act, Financial Institutions Act, Mutual Assistance in Criminal Matters Act, FATCA, Global Forum, and the list goes on and on and on. What we did is that we went behind all of the areas where there can be abuse of public monies. And we didn't stop there. We then went to the courts. We then multiplied the judiciary. We created divisions of court. We put in rules to cause the processing of claims. Listen, the offenses under the Public Procurement Act could easily have suffered the fate of every other offense in this country on the criminal law side. How many judges you have dealing with it? Do you have a public defender system to represent people? Do you have criminal proceedings rules? Do you have masters to case manage? Have you removed 97% of the backlog? Have you done we did all of that. We did all of that. So the first thought process that went into this was putting this law into a place that is very different from where it was in 2015. In 2015, when the UNC brought this law forward, there were 2 masters in the High Court. We up to 25. There were no rules in the criminal procedures. We now have rules. They had magisterial districts all over the place. We now have 3. We have electronic filing. We have 15,000 virtual hearings going on every 3 months. We're in a totally different scenario. Taking out marijuana resulted in 8,500 cases falling aside. Taking out the traffic resulted in 104,000 cases moving from 146,000. Taking out the preliminary inquiries as we're gearing up for full operationalization will take out another 26,000. You're looking at 8,500 cases as opposed to 146,000 cases. So our landscape is completely different. That's 1. 2, we drafted the campaign finance law. The brother or sister to public procurement law is campaign finance law. We brought whistleblowing law. The UNC refused to support it. We brought white-collar offenses into anti-gang laws. The UNC allowed that to collapse. So we were looking for gang activity, including white-collar crime, which included bid rigging. Bid rigging is a feature of public procurement law. All of our pieces are connected, all. Not some, they're all connected. That probably tells you why the UNC doesn't want to support, because they've consistently not supported any of the things I've just referred you to. When we went and we amended the Income Tax Act to allow the police access to information, they said no. When we went and we amended the Financial Institutions Act, the Securities Act, the Central Bank Act, to allow the police to get witness statements to file in court, they said no. So the UNC, in my respectful view, from the facts, would never be interested in supporting a law like this. So the thought process to putting this law together was where you are applying the law and how. Secondly, in the 2 years, going on 3, that we have had position in relation to this law, because this law didn't start to become real until the regulator was appointed January 12, 2018. Now we are at the point of regulations, but the regulations are not the be-all and end-all. It's how you bring it to life. Do you have a review panel? Where is their office? How does the one regulator and his structure deal with thousands of challenge proceedings all at once? Because if you raise a challenge proceeding and you don't have the processes to deal with it, shut down the place. So that's the thought process.
One more from me. I noticed that you guys, the government took advice from the independent senators you mentioned a couple of minutes ago. And well, it seemed that you took the information and the advice to heart, and it seemed to be valid. Was there any other organizations, even if it's opposition, were there any other organizations that suggested something that would have enhanced the OPR, the procurement laws?
No. Senator Paul Richards, Senator Vera, the senators, not the opposition senators, were the ones that brought forward comments. The opposition's view, I mean, Mrs. Prasad Bisesa didn't make a single proposal in the committee stage. She never does. When you're lucky enough to see her in the parliament, there are no submissions coming from the opposition bench. Anti-gang came and left without a single submission. They couldn't tell us what was wrong with the law. Not one recommendation. So we're accustomed to those factors, but we've taken our time to demonstrate that we are not alone in the amendments that we cause. I've given you from the European Union to the United States, to the Caribbean models, to UNCITRAL, to CARICOM model law, to Africa, to the Asia Pacific. I've given you examples where everywhere else in the world they have this. And I've cautioned, no treaty can oblige Trinidad and Tobago unless it becomes law. So you have to take the treaty to Parliament. An international financing arrangement with an international funder is not OAS Constructura. It is not the Piarco Airport contract. And we've also demonstrated Section 29 applies for due diligence, and the regulator has to go there. Senator Mark's ridiculous, untruthful submission that assets are not governed by the law is the figment of somebody who is incapable of telling the truth, because it's right there in black and white. And it's not only in the law to say, well, it's technical and somebody can't understand it. It's in the manuals produced by the regulator as well. So Senator Mark is not on his own. He had a whole UNC with him, and he's rowing the boat. Captain of the ship that is going nowhere. Sure.
Two things. Has the government put in a defense in the helicopter, the case involving the lawsuit for the helicopter?
There are three cases.
Purchased,
Which one are you talking about?
The one that was purchased under Mr. Gary Griffith's tenure. And the claim is that the helicopter never came here or something like that.
Okay, the UNC presided over the purchase of several helicopters. In one case, well, we know the helicopter was a mechanism of preferred choice, right? I noticed that people talking about cars for parliamentarians. In the UNC's case, we're talking about helicopters and the passage between Philippines and Port of Spain with thousands of dollars trip either way. The helicopters purchased by the UNC included helicopters that never arrived but were paid for, some that came that couldn't have positions. But in the particular case that you're referring to, that matter is the subject of management by lawyers outside of Trinidad and Tobago. Secondly, I'd not like to say too much about it because it's something that we have to pay attention to in pre-trial arrangements, etc., and even trial arrangements. But thirdly, what I can say is that it was Attorney General Anand Ram Logan that took a decision in that case that was materially disadvantageous to Trinidad and Tobago. And that was supervised by the Prime Ministership of Kamla Prasad Bisesa. So this has nothing to do with Gary Griffith at all. This has to deal with the National Security Council, headed by Mrs. Prasad Bisesa, and the advice that the government then implemented. So I don't want to get too deep into the case, because obviously we now have to act in the best interest of the taxpayers of Trinidad and Tobago.
All right. The only reason I mentioned Mr. Griffith, I think he was specifically named in the matter. So
the Minister of National Security would have acted as a functionary.
Okay.
The advice for contracts comes from the AG. I supervise all contracts that have to come to me, not all necessarily, right? But we're really looking at the questions will go back to Mrs. Prasad Bisesa and others, insofar as the Prime Minister ought to be, the then Prime Minister ought to be telling the country about certain matters.
Okay. The other matter relates to, there is some doubt about the veracity of statements that you made in response to, well, not you made, that the Attorney General responded through the government leader, Clarence Rambarat, in the Senate with respect to the Sentencing Commission.
Sorry, I didn't hear what Minister Rambarat said, but...
Well, I assume he got the response from the, because the question
Let's get to the chase. Well, what is it you want clarification on?
The position is there's a position that Mr. Gregory Delzin said very clearly that he was prepared to accept accommodation other than Tower D. You said well, the response in Parliament said that he had specifically asked for the Sentencing Commission to be housed at Tower D, and this was not possible because, of course, the civil courts are going there. There has been circulating a response from Mr. Delzin which said that he had agreed for alternative accommodation and that aspect of the response did not represent his position. So
I'd have to get back to you on it. I did receive a phone call from Mr. Delzin telling me, look, everything that the newspapers reported has nothing to do with me. I don't associate myself with anything that was said there.
Right.
So he cautioned me about the reports that came from your newspaper.
Well, it was what Mr. Rambarat said.
I know, but you see, now we're into this glorious he say, she say. And I wasn't there in the he say, she say, so I'd like to find out. I have regard for Mr. Delzin, I have regard for Mr. Rambarat, etc. So it's sounding too complicated to give you an off-the-cuff answer. I'd have to get some details for you.
What more in the he say, she say department, sir?
Sure.
Okay, Ryan Hamilton Davis again. Well, there was another situation where, with some confusion, where I hope you could clarify, and that's with the release of prisoners. That's concerning over concerns of COVID-19 as well as marijuana, marijuana legislation changes and so on. The Prison Service Association has said, according to their information, no special releases under either regard has been done, but it has been reported. I don't know if it's accurate or not. It has been reported, all right, that you said that hundreds have been released under this facet. I mean, what is
okay,
it really?
so let's get to that. Again, we have to be careful with information. We went to court in two very novel matters at the beginning of the year. One concerning decriminalization, and secondly concerning COVID. What we did was to go to the court and aggregate all of the information. We established a list and position, and what we did is we caused for different ways in which prisoners could be released. The easiest of which is using the existing prisons laws, the Act and the regulations, where the Commissioner of Prisons has the ability to take people out of the system, which we went through with the Commissioner, and I can confirm that hundreds of people have come out as a result of that mechanism. I can also confirm that some people were brought before the court. The Public Defenders Division that we created represented many people. We had bail applications heard. The court then decides its position. I could say for certain, 2 young men were immediately released under the 2 teenagers for very small and ridiculous quantities of marijuana from Tobago were released, and I could give you classic examples of those. I can tell you that some matters involve arrangements that have to go under the issue of pardons, which have to be dealt with by the President pursuant to the advice of the Minister of National Security and the Mercy Committee under Section 87 of the Constitution. As a result of a case called Lendor, people now have to give representations to the committee. You can't do it en bloc. You have to do it individually. So an entire system has been put into place as a result of that case to manage those matters. So it isn't that the cases resulted in the courts setting free a whole set of people. We didn't put our eggs in one basket. We went for Commissioner of Prisons releases, bail applications, Mercy Committee, and the DPP, very importantly, is the last leg, where the DPP is looking at the information to decide if he's going to end prosecutions against people who are before the courts. Okay, so I hope that helps.
Right, just follow up real quick, just to show
The Commissioner of Prisons releases, that mechanism is so far the only one working.
Well, they're all working. The question is that they're in various stages. Let me bring this to mind, right? When you are looking at the court releasing someone, it isn't a simple matter, you know. Very often people may find themselves in prison for marijuana and rape, marijuana and attempted something else, burglary, larceny, whatever it might be. So you don't have the classic case of standalone marijuana offenses. What you have is mixed offenses. And when you are dealing with the criminal law, you have to be really careful about relieving the issue of bad character. Because in future prosecutions, you may want bad character evidence that you don't want to give up that easily. So it's not as simple a mechanism as one would make it out to be, but suffice it to say, the courts have heard bail applications, the public defender system. You may be surprised to know this, folks. We have over 400 people ready to plead guilty in matters right now because of the work of the Public Defenders Division, including over 131 people for murder felony. Let me repeat that. As a result of the work that this government has done in birthing the Public Defenders Division and the excellent work by the Public Defender herself, the Chief Public Defender, Ms. Sheikh, I can confirm to you today that there are 131 people, if I remember the number, who are ready to plead guilty for murder felony. And over 400 in total and counting ready to plead guilty. That requires the indictments to be filed by the Office of the Director of Public Prosecutions and to come before the courts. So we are headed into a brand new zone in Trinidad and Tobago where all of the things that we have put into place are beginning to work. That's it. Thank you for your riveting line of questions, all of you. And can I take this opportunity to offer my personal compliments to each and every one of you in this Christmas season. We're seeing some very interesting events in the global horizon. Just when you think you're out of the bamboo, a new patch comes up, and we think it prudent to reflect upon the good in Trinidad and Tobago. The rest of the world is now shutting down. We are not. Something is surely right about us. It's a time for us to be measured. It's a time for us to remember that there are raging issues all around us. We could find ourselves in difficult circumstances, but we have to continue to obey the law, arrange ourselves in a careful way so that we don't prejudice our elderly, our at-risk population, especially in the COVID structure, resist the urge to be too much in mingle and association. And I really would like to express my wishes for Trinidad and Tobago to have a very safe and holy Christmas season where we remember those who are less fortunate than we are. All of us who are members of Parliament are very heavily engaged in providing as much assistance as we can to our constituents who are in difficult situations. If you listen to the BBC, did you hear their report on the United States of America and other developed countries? The millions and millions of people that are in distress in what we consider to be first world countries. Let's say, thank God, that Trinidad and Tobago is what it is and that our people still have a sense of rectitude and care for each other. And notwithstanding the battles, etc., that we undergo, I really do think that our best days are ahead of us. So Merry Christmas to you all. I wish you the very best of this season, a very safe and holy Christmas season. And thank you very much for coming to today's event. Thank you.